Friends, uh, for AIB preparation, we discussed previous year questions for last 10, I think, or more. We discussed CRPC, CPC, Constitution, Indian Evidence Act, and other important sections, which would cover almost like 60 marks question paper. Remaining 40 marks will be from other topics like industrial law, uh, then particularly with respect to the professional ethics, banking, taxation, etc. So now we will be discussing the remaining topics, which would cover approximately 30 to 40% of the marks. So let us start with the labor and industrial law. Payment of compensation to railway employees by the railway administration for injury by accident is governed by Employees Compensation Act 1923. A railway servant was killed in a bus accident during the course of employment. His family members may claim compensation under Motor Vehicle Act or the Employees Compensation Act 1923. Either of the act they can claim because it was a bus accident and is also a railway employee. Minimum amount of the compensation payable under the Employees Compensation Act 1923 is 1,40,000. Schedule 2 of Employees Compensation Act 1923 deals with the list of the persons who are included in the definition of employee as per the Industrial Labour Act. A teacher is not workman within the purview of the Industrial Dispute Act held in the case of Sundaram Boy versus Government of Goa. Teacher is not labor or a workman under the Industrial Dispute Act was decided in the case of A. Sundaram Boy versus Government of Goa. According to the Factories Act, child means a person who has not completed his 15th year of age. Mere illegality of the strike does not per se spell unjustifiability. This is what Justice Krishna Iyer quoted in the case of Gujarat Steel Tube versus Gujarat Steel Tubes Mazdoor Sabha. Workmen aggrieved by the order of dismissal, discharge, retrenchment or otherwise termination of the service may directly make an application to the labor court or a tribunal for adjudication of the dispute, and the court tribunal is empowered to adjudicate such a dispute as it had been referred to by an appropriate government. Section 2J of Industrial Dispute Act 1947 defines the industry as business, trade, undertaking, manufacture or calling of employers, included any calling, service, employment, handicraft, industrial occupation of workmen. All are these considered they are covered under the Industrial Dispute Act section 2J. Ensuring the safety, health, welfare of the employees is the primary purpose of the Factories Act 1948. In which case Supreme Court held that teachers are not workmen. Sundaram Bal versus Government of Goa. The permanent closing down of a place of employment or part thereof is given under the section 2cc of the Industrial Dispute Act 1947, section 2cc, which is considered as a closure. Industrial dispute means any dispute between employers, employee, employers, workmen, workmen and workmen, master and worker. 1, 2, 3, that is employers and employers, employee and employee, that is workmen and workmen, and employers and workmen. These three are considered industrial dispute. Industrial establishment means it is a factory, a mine, or an industry or a plantation. Strike should be called only if at least how much percent? 15% of the employees or workers are in support of the strike. Then it is considered the strike as a legal strike. 15%. Industrial relation covers the following areas: collective bargaining, labor legislation, and industrial relation training. Who is protected workman? Workman who is an executive or an office bearer of a registered trade union in the establishment is a protected workman. Meaning of industrial dispute according to Industrial Dispute Act 1947, already discussed, between employer, workman, employer and workman. Section 49 of the Factories Act 1947 explains about the welfare officer. Welfare officer is covered under the section 49 of the Factories Act. Unfair labor practices by the employee includes victimization, false implication in criminal, untrue allegation of absence without leave. All these are considered unfair labor practices. Under the Workmen's Compensation Act, which is helpful in deciding the extent of injury for the compensation, is the medical examination and medical certificate. These two are they are helpful in deciding the extent of the injury. Medical examination and medical certificate, not insurance certificate. Section 23 of the Workmen Compensation Act 1923 says that commissioner shall have the power of a court. Objective of the Industrial Dispute Act 1947 is to ensure the industrial peace and economic justice, to create harmonious relation between the employer and employee, to prevent illegal strike or lockout. Section 2Q of Industrial Dispute Act 1947 is with respect to the lockout. Government employees may refer their unresolved grievances and labor dispute with the Bureau of Labor Relation. Who is an adolescent as per the Factories Act? Anyone who is more than 15 years but less than 18 years is an adolescent. Anybody more than 18 years is an adult. Who is responsible for payment of a person employed him in the factory under the Payment of the Wages Act? The owner of the establishment is responsible for payment of the wages under the Act 1936. To close down a factory, the occupier has to give how many days notice? 60 days notice is required to close down any factory. Under the provisions of the Trade Union 1926, any person who has attained the age of 18 years may be a member of the registered trade union subjected to any rules of the trade union. 18 years is an adult person who can be a member of the registered trade union. The provision of Cooperative Societies Act and Companies Act 1956 do not apply to the trade union registered under the provisions of the Trade Union Act. The provisions of the Cooperative Societies Act as well as the Companies Act 1956 do not apply to the trade unions registered under the provision of Trade Union Act 1926. Trade union is covered under the specific industry definition which we have discussed. Which of the following can be considered retrenchment under the provisions of the Industrial Dispute Act 1947? Retrenchment is reducing the employees based on the situation of the owner. So it is not due to the termination of ill health or abandonment of the jobs by employee or termination on account of the reach of the age of a superannuation. None of these are the retrenchment. Which of the following statements holds true regarding imprisonment under the provisions of section 14(3) of the Child Labour Prohibition and Regulation Act 1986? It may extend to 1 month with respect to the imprisonment if anybody employs the child. Under the provisions of the Industrial Dispute Act 1947, appropriate government can, by order in writing, refer to the dispute to the board for promoting the settlement, or refer any matter appearing to be relevant to the dispute to any court for inquiry. Both are relevant with respect to the Industrial Dispute Act, where the appropriate government can, by order in writing, can give. Which of the following statements is true for loss of confidence by the management in the workman? Even when the dismissal or a discharge is held to be the wrongful, court may not yet order reinstatement if the employer is able to establish that the workman held a position of trust, that there was a loss of confidence. Or loss of confidence may also be the ground for the discharge of the simpliciter of the workman. These are the two reasons. Mere illegality of the strike does not per se spell the unjustifiability. This is held in case by Krishna Nayyar, Justice Krishna Nayyar, in case of a Gujarat Steel Tubes versus Gujarat Steel Tubes Mazdoor Sabha. Pick out a case that is popularly called as a solicitor's case. It is a National Union of Commercial Employees versus Industrial Tribunal, Bombay. This is called the solicitor's case. Identify the case that is related to the need for the promotion and preservation of the internal democracy within the trade union. This is held in case of a Hanumant Rao versus Deputy Registrar of a Trade Union. Rashtriya Swasthya Bima Yojana is mainly to serve the needs of unorganized sector working belong to the BPL category and their family members. It is for the unorganized sector, Rashtriya Swasthya Bima. Equal pay for equal work for both men and women is proclaimed under the Article 39D of the Constitution of India. 39D calls for the equal pay for the equal work. This is one of the directive principles of the state policy. Where any workman is suspended by the employer pending investigation or injury into the complaints or charges of the misconduct against him, the employer shall pay to such workman subsistence allowance. This provision was inserted in the Employees Standing Order Act 1946 in 1982. The case Bank of India versus Kelawal versus other was a leading case on a point that as to whether an employer has a right to deduct the wages unilaterally and without holding an inquiry for the period of that employee go on strike or a resort to go slow. Bank of India versus T.S. Kelawala and others. Under the Industrial Dispute Act, if the employer terminates the services of an individual workman, any dispute difference arising out of such termination shall be deemed as the industrial dispute. Sampurna Gramina Rozgar Yojana, Universal Rural Employment Program, was launched in 2001 and was implemented through Panchayati Raj institutions. UNREP 2001 implemented through Panchayati Raj institutions. The provisions under the Industrial Dispute Act 1947, which guarantees the right of workmen laid off to a claim, Section 25C for a compensation. Section 25C of Industrial Dispute Act 1947 related to the claim for the compensation when a workman is laid off. Number of persons required to form a trade union is 7. The temporary closing of a workplace or suspension of the work at a workplace by the employer is known as lockout. Which of the following acts has a direct relevance for a grievance of handling practices? Industrial Dispute Act, Factories Act, Industrial Employment Standing Order. All are related to the labor acts. Section 10A of the Industrial Dispute Act refers to the voluntary reference to the disputes to arbitration. 10A, which is an amendment to the Act section, is reference to the arbitration. Wages under the Workmen Compensation Act includes any privilege or benefit which is capable of being estimated in money. Contravention of Contract Labor Act should not create employment relationship between the contract labor and principal labor established. It was held in case of a SAIL versus National Union for Waterfront Workers. Principal regulatory envisaged under the Trade Union Act is the Registrar of the Trade Union. Registrar of the Trade Union is the head of the head for the organization which is under Trade Union Act 1926. A teacher is not workman, which is held in case of a Miss A. Sundaribal versus Government of Goa. The type of the disablement envisaged under the Employment Compensation Act that reduces the capacity to work in any employment similar to that of the worker was performing at the time of accident is equal to permanent partial disablement. Contribution payable to the ESI Act in respect of an employee shall comprise of contribution payable by employer as well as the employee. Section 25C guarantees the right of the workman to claim the compensation under the Industrial Dispute Act 25C. The term lockout is referred in the Industrial Dispute Act section 2I. The term layoff has been defined under section 2KKK. Friends, you need to remember the definitions of the various sections under the Labor Act because at least one or two questions, minimum two questions are expected with respect to this one. Trade Union Act was enacted in 1926. The term minimum wage has been enacted with the Minimum Wage Act. These are all related to the Trade Union and Industrial Labor Act. We can expect at least 3 to 4 questions from this. If you have the Labor Act, bare act, then comfortably you can get these 2 or 3 marks. Thank you, and we'll continue with the next session on the law related to the taxation. Health and education cess is applicable to all the SSCs irrespective of their any cadre or any designation. Rate of additional depreciation will be 20% under the section 32 of the Indian Income Tax Act. Amount of deduction under the section 24 of the income tax from an annual value is 3/10 of the annual value. A company which is not a domestic company will pay 40% income tax. That is what 40% of the income they pay, which is not a domestic company. The definition of money under the GST is the currency held for a numismatic value. Currency held for a numismatic value. What are the kinds that currency? That is the money under GST. Under Article 279A, GST Council is constituted by the President of India. According to income tax, zero coupon bond means it is issued by the Infrastructure Capital Company as per the first day of the June 2005, in respect of which no payment or a benefit is received or receivable by the maturity, which of the central government may by notification in official will specify on this behalf. All of these are considered to the zero coupon bonds. Provision related to GST are inserted in the Constitution 100 First Amendment Act, that is 2016. GST introduction was 101 of the Constitution. For the first time in India, income tax was introduced by Sir James Wilson in the year 1860, in which case C. Shah of the Supreme Court observed, since by the exercise of the power a serious invasion is made upon the rights, privacy and freedom of the taxpayer, the power must be exercised strictly in accordance with the law and only for the purpose of which law authorizes. Nobody can impose the taxes except as per the law. This is a case with related to ITO versus Seth Brothers, Income Tax Office versus Seth Brothers. The principle of the law of taxation, that no tax shall be levied or collected except by authority is given under the Article 265 of the Constitution. 265 of the Constitution is related to the law of taxation. Under which section of Income Tax Act, income of other persons included in assessee of the total. Section 60 to 65 sections of the income tax, income of other persons is included. Under which section of the income tax 1961, income of the other persons is the same question, 60 to 65, two times it appeared. A period of 12 months for commencing from the first day of April is the assessment year. Adam Smith has enumerated canons of the taxation which are acceptable universally. They are based on the equality, certainty, convenience and economy. Equality, certainty, convenience and economy. For the first time in India, income tax law was introduced by Sir James in the year 1860. Permanent account number is defined in the Income Tax Act 1961. Section 29 of the Wealth Tax deals with the appeal in the Supreme Court. Section 29 deals with appeal in the Supreme Court. GST bill was passed in 2016. It came into the effect from 1st July 2017. Section 154 of the income tax is for the rectification of the mistakes. 154 for the rectification of the mistakes. Which of the following is not included in the capital asset under section 214 of the income tax? Any stock in trade or special bear bonds. These two are not included in the capital asset as per the Income Tax Act. Income Tax Act enacted in 1961. Income is defined under section 24 of the income tax. In case of a cooperative society, the maximum amount on which the income tax is not chargeable is 0. An appeal to High Court against the ITAT should be filed within the 60 days when the order is communicated. Income Tax Assessment Tribunal, if the appeal is to be done within the 60 days. Indian Computer Emergency Response Team, ICERT, to serve the National Agency for the Incident Purpose is constituted under the Section 70B of the IT Act. Indian Computer Emergency Response Team is constituted under Section 70B of the IT Act. Incomes which are accrued or arise outside the India but are directly received into the India are taxable in case of residents, ordinary residents and non-residents and non-residents. All of these are their assessees. Which of the following belong to the category of the direct tax? Goods and service tax, excise duty, customer, income tax and gift tax, all of the above. Income tax and gift tax are the direct taxes, CBDT, and income tax, goods tax, services tax, GST, excise duty, custom duty, they are the CBDT. That's the indirect taxes. This is all about the income tax. Friends, now we will be discussing the professional ethics because only 2 or 3 questions from each sections may come. So professional ethics and misconduct rules under the BCI will be discussing based on the previous question. Advocate Act 1961 came into force on 19th May 1961. Advocate Act 19th May 1961. Punishment of advocates for misconduct has been given under the Section 35. Section 35 talks about the punishment to the advocates under the misconduct. An advocate is under obligation to uphold the rule of the law and ensure that the public justice system is enabled to function at its full potential. Any violation of the principle of the professional ethics by an advocate is unfortunate and unacceptable. This is held in the case of O.P. Sharma versus High Court of the Punjab and Haryana. The maximum limit of the members of the State Bar Council is 25. State Bar Council maximum limit is 25. The Bar Council of India has to lay down the standards for the professional conduct and etiquette. Section 7(1)(b) of the Advocate Act defines what are the rules for the professional conduct by the advocates. Section 7(1)(b) of the Advocates Act 1961. According to Section 49 of the Advocates Act 1961, qualifications of the members, class or a category of the persons, standards of the legal education, all are specified under the Section 49 for an advocate as per the Advocates Act 1961. Among other things, Bar Council of India includes laying down the standards of the professional conduct and ethic under Section 7. Here we can see that was a Section 7(1)(b). Here we refer to the Section 7. According to the Justice Abbott Parry is the one who derived or defined the 7 lamps of the advocacy. The 7 lamps of the advocacy includes honest courage, industry, wit, eloquence, judgment, and fellowship. Which of the following can be done by a senior advocate in accordance with the rules of the Bar Council? This is with respect to the senior advocate. Senior advocate makes concession on behalf of the client on instruction from the junior advocate, accept the instructions to draft a pleading, accept briefly direct from a client, none of the above. He accept the instructions to draft a pleading. Which of the following is not a duty of an advocate? Not to breach the Section 126 of the Evidence Act. 126 of the Evidence Act should not be breached. Which of the following rules of the Chapter 2 of the Part 4 of the Bar Council deals with the duty of the advocates? Rule 25 deals with the duty of the advocates in respect of any money received from client, like maintaining the accounts and all those things. Which of the following provisions of 1961 Advocates Act provides for the power of the Bar Council to withdraw itself any proceedings for the disciplinary action? Section 36(2) gives the power to the Bar Council. Disciplinary Committee of the Bar Council conferred with the powers of the Civil Court under the CPC 1908 under Section 42 of the Advocates Act 1961. The designation senior advocate is provided under the Section 16 of the Advocates Act. Right to pre-audience is provided under Section 23 of the Advocates Act 1961. Contempt of the court belongs to entry 77 of Union List and entry 14 of the State List in the 7th schedule. Contempt of the court with respect to the Union List and State List, 77 entry and 14 entry. Section 24A of the Advocates Act provides appointment of the Attorney General, regular attendance of the law college, admitted to the enrollment to the bar or state roll, election of the state. It is admitted for the enrollment in the bar or state roll. Punishment for the advocates for a misconduct is defined under the Section 35. Which is the body that awards the punishment? It is a disciplinary committee, which is equal to the having power of the court. Which is the correct statement with regards to the professional ethics of a lawyer? Lawyer have no right to go on strike or keep a court for boycott. Advocate shall not influence the decision of a court by any illegal. Advocate abusing the process of the court is guilty of and misconduct. All of them are correct. Which is the punishment for the advocates if the established find the Bar Council is misappropriation? They can impose a fine. They can name of the advocate will be struck off from the rolls or suspend from the practice. On being aggrieved by the order of the State Bar Council, one can appeal to the Bar Council of India. Section 24 of the Advocate deals with the qualification that who should be enrolled in the bar. In which case did the Supreme Court held that misconduct envisages breach of a discipline? Noratnami Chaurasia versus M.R. Murli. Vikramaditya versus Srimati Jamil Khatun is an important case related to the defrauding the client by exploiting the client's illiteracy. Vikramaditya versus Srimati Jamila Khatun. This is one famous where advocate misuses the illiteracy of the client. Which of the following case is a leading case with respect to the deliberate delay in filing the suit? Professor Krishnaraj Goswami versus Vishwanath D. Mukherjee. Any person aggrieved by an order made by the disciplinary committee by the Bar Council, section 36-37, can approach Supreme Court. Appeal is allowed after the Bar Council of India disciplinary committee takes any action against the advocate. They may approach under the section 36-37 of the Act to the Supreme Court. State Bar Council under the section 35 has authority to punish the advocates. Which of the following is untrue regarding the qualification of the person to be admitted to the state bar councils? Untrue regarding the qualification of the person. He must be Indian citizen. He must have been convicted of an offence. So he must be Indian citizen. The Bar Council of India rule, which stipulates the persons aged 45 years and above could not be enrolled as advocates, was struck down by the Supreme Court in case of an Indian Council of the Legal Aid versus advice to the Bar Council of India. A Supreme Court held in V.C. Rangadurai versus D. Gopalam, where he possessed the good character necessary to guarantee upright and honor in his professional dealings. In which of the cases this issue had come, whether the advocate had committed a professional misconduct and guilty of the sin. Vinay Chandra versus a reference to this case. Misconduct would cover any activity of which is a professional brethren of the good repute and competency. This is referred in the Bar Council of Maharashtra versus M.V. Davalodkar. Retention of the money deposited with the advocate for a decree holder even after the execution of the proceeding was held as an instance of a misconduct in case of a Prahalad Sharan Gupta versus Bar Council of India. In which case, where the advocate, one of the parties, was asking for a continuous adjournment, N.G. Dastana versus Srikant Shinde. General power of the Bar Council to make the rules is envisaged in the section 49. 7 laps of the advocacy is attributed to Justice Aubert Parry. Which section of the Advocates Act speaks the disciplinary powers to the bar? That is 36. Section 39. Section 9A of Advocates Act speaks about the constitution of the Legal Aid Committee. Legal Aid Committee is referred in the section 9A of the Advocates Act 1961. Who has the authority to prescribe the qualification and disqualification for a membership of a Bar Council? Bar Council of India. Indian Council for the Legal Aid and Advice versus BCI case deals with the prescribing the age bar and enrollment of the advocates. For transfer of a role from one state to another, an application is made to the Bar Council of India. One high court to other high court or one state to other state has to be given to the Bar Council of India. Which of the following committees cannot be constituted by the State Bar Council? Legal Education Committee cannot be constituted by State Bar Council. It is by the Bar Council of India. Friends, these are all some of the important cases. When was the Advocate Act introduced in 1961? Bar Council of India consists of the ex officio members, Attorney General of India and Solicitor General of India. Indian Bar Committee was constituted first time under the chairmanship of Sir Edward Chamier in 1923. Power of the Disciplinary Committee is under the Advocate Act section 42. So these are all the questions with respect to the professional ethics. And now we'll be discussing the public interest litigation. There are 3 to 4 questions are expected. Misuse mechanism of the PIL is considered the filing the PIL for protection of the private interest or oblique motive or only for the publicity. These are all considered the misuse of the PIM mechanism. Phrase file a PIL ostensibly in public interest but in fact serves personal or private interest means filing a PIL alleging it to the public interest but actually seeking a protection of a private interest. Filing a frivolous PIS results in waste of resources, lesser availability of the time for hearing, increasing the backlog of the cases. Anuradha Basin versus Union of India on 10 January 2020 related to a challenge under Article 32 of the Constitution seeking issuance of an appropriate writ for setting aside the orders of the government by which all modes of the communication including the internet have been shut down in J&K. Utility of the public interest in litigation is liberalized local standing, proceeds are non-adversarial, procedures required or requirements are liberalized. Keshavananda Bharati is one of the important, uh, but it is not a case of a public interest litigation. It was a private. However, based on this one, the basic structure is also defined. Purpose of the writ quo warranto is to oust illegal occupant in a public post. Writ of the certiorari can be used against the judicial and quasi-judicial bodies. The Chief Justice of India, when the concept of a PL was introduced, was P.N. Bhagavati. In which country the concept of PL is originated? United States of America. Mandamus may be issued either by Supreme Court or by High Court. Mandamus is the order to the government to issue an order. Which of the following writs means to produce a body of the person? It's a habeas corpus. A landmark habeas corpus petition was filed during the emergencies, the famous ADM Jabalpur versus Shokant Shukla. Who can move PAL in High Court and Supreme Court? Any public spirited person, NGO, group of public spirited persons who have the personal interest. Delhi Domestic Working Women's Forum versus Union of India. In this PIL, the issue exposes the plight of domestic women or domestic maids who were sexually assaulted by army men. Which one is a case of a public interest? Vishaka versus State of Rajasthan, Minerva Mills, Municipal Corporation of Ratlas is a Vishaka versus State of Rajasthan is a public interest. Custodial death is perhaps one of the worst crimes in a civilized society. This is in the case of a DK Vasu versus State of Bengal. Due to the outcome of the case, slum dwellers were benefited in case of Olga Tellis versus Bombay Municipal Corporation. A public interest litigation can be filed under Article 226 and Article 32 of the Constitution and also Article 133 of the CRPC. So, answer is A and B. Supreme Court in PIL known as a Kamal Nath versus case involved is a public trust doctrine. Vishaka versus State of Rajasthan is related to the sexual harassment at the workplace. PIL is criticized on the ground of a private motives, political ends, tremendous increase in the litigation, all of them. When can the Supreme Court refuse to grant the remedy under Article 32? When there is a undue delay, malicious petition or infrastructure petition. Filing with the court to object on or another imprisonment is called the habeas corpus. Which writ is issued by the court to quash the wrongful order of a lower court? It is a certiorari. So these are all related to PIL, and I think with this we complete the session, and with respect to other topics we'll continue in next session. Thank you very much. Hope this will be useful.